Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about a piece of Alberta legislation, changes to their provincial Bill of Rights. The Alberta Bill of Rights was first introduced over 50 years ago by Premier Peter Lougheed. It's a statutory Bill of Rights, so not a constitutional document, and it's meant to protect the people of Alberta from intrusions into their rights. Now, Alberta Premier Danielle Smith has proposed some updates to that Bill of Rights, and it expands in four areas. It deals with freedom of expression, not exclusively freedom of speech. It's designed to protect Albertans against unwanted medical care, though there are some exceptions. And it deals with expropriation of property as well as firearms ownership. It may make it more difficult for governments to appropriate property. Now, here today to discuss this and the proposed changes are two experts, political science associate professor Lori Williams and assistant law professor Lorian Hardcastle. Thank you both so much for joining me today. I want to get your reactions first to my description of what the Bill of Rights amendments are. It's sort of in those four areas: firearms, medical care, expropriation, and freedom of expression. Lorian, I'll start with you. What would you add to my description to sort of flesh out that framework?
I think that in addition to talking about the different areas of rights that are going to be expanded, the Bill of Rights also will talk about the limitations on those rights. So reasonable limits, and the language that they're using is in a free and democratic Alberta. So that invites courts to maybe think about what an Alberta specific version of that looks like. Another thing that I think is interesting here is that a lot of these rights, the way they're worded, is rather broad and vague, and so a lot of the work is really going to be done in the courts. And so, in some ways, what the case law that's going to evolve over the coming years will be even more interesting than the amendments themselves.
So, Lori, why do you think the Alberta government has introduced these amendments? What's behind all this?
Well, it's largely because of pressure being brought by the right flank of the United Conservative Party. The former Wild Rose Party sorts of folks are involved in this, and there are now three different groups that claim representation of them. One of them is Take Back Alberta, which people are already familiar with. Another is what's called the Black Hat Gang, and they in particular put together proposed amendments to the Bill of Rights that were sort of taken up or adopted or recommended by the board of directors. The third group is called the 1905 Committee, presumably referring to Alberta being formed in 1905. And we've actually seen reactions from all three of those groups, basically saying that it falls short of what they're looking for. And I think affirms what most of us, when we look at this, wonder is this more than just simply symbolic?
Yeah, what's your take on that, Lorian? Do you think that this is actually going to have a meaningful impact on how Canadians' rights will be protected? I mean, I think of Canada's Bill of Rights, a piece of federal statutory rights guarantee, and how it's not often relied on. It only applies to federal statutes. It's not really, doesn't seem to be used that much. So, what type of impact do you think this will have?
I think the impact is going to be fairly minimal. A lot of what's in here are rights that we already have in other forms anyway. So, for example, some of the rights around freedom from medical coercion, I think that we would already say that that's implied in the right to life, liberty, and security of the person, that you can't be subject to unwanted medical treatment. And then we also have common law cases in battery, which say that people have the right to be free from unwanted medical coercion. So I think that a lot of what's happening here is symbolic. It is a gesture to the members of the party who were dissatisfied with what went on during COVID-19.
Yeah, I think that that's something I want to get into in the next segment when we have more time, because the medical question is really interesting to me. I mean, certainly it seems like this is introduced because the members of those different parts of the party that Lori described, and I think a lot of members of the public were dissatisfied with the protections of the common law on medical choice. So We'll be able to get into that in the next segment, but we do have to go to break. When we come back, we're going to expand on that whole conversation. Welcome back to Canadian Justice, where we're discussing the proposed amendments to the Alberta Bill of Rights. Now, one of the sections of the Alberta Bill of Rights deals with choice in medical care. It deals with specific, the term they use is coercion in medical care or forced medical care. And Lorian, you brought this up in the last segment that there are supposed to be common law protections against forced treatment. That there already is law on this, but a lot of members of the UCP base seem to have been dissatisfied with how those protections played out during the pandemic. Do you think that this proposal actually would prohibit things like vaccine mandates, or maybe not?
Yeah. So I think what's interesting is a lot of it will come down to how a court interprets that principle of coercion. I think we can all agree that forcing people to be vaccinated would be coercive. And actually, the government got rid of that power from the Public Health Act during COVID-19. But then it would be open to a court to conclude whether or not a vaccine passport system is coercive. And maybe that would depend on, is it prohibiting people from only accessing non-essential services or essential services? Would requiring vaccines to attend schools be coercive? And maybe not, if there are exceptions and carve-outs like Ontario's school vaccine law. So really a lot of what that coerciveness will come down to is how a court interprets that language.
What's your take, Lori? How are people reacting to this? Perhaps in the public, or even within the political, the elected politicians? Do they think that this does what they want in order to prevent what they see as this problem that they had with vaccine mandates?
So the people who made the demands in the first place, so that would include the Take Back Alberta folks. David Parker has tweeted about this and says that he feels like this is inadequate and it doesn't recognize God-given rights over certain things. We're also seeing reaction from the 1905 committee saying that this again doesn't meet the standard. And the lawyer associated with the Black Hat gang, Leighton Gray is his name, has basically said that this is a ploy. It's somehow a dodge. It's not fulfilling the requirements. So there's a sense, certainly from these very high-profile participants, the leaders in each of these groups are saying that it is wholly inadequate. They want it to be reviewed much more explicitly at the annual general meeting. And I think it could spell more trouble in the leadership review than perhaps I thought would be the case before the introduction. The other thing to bear in mind is that there are those, let's say the NDP opposition, are arguing that this nobody asked for this. It's not focusing on the priorities of Albertans. Most people are concerned with healthcare and affordability. Now that should be the focus, and not this Bill of Rights that looks at things that may or may not have an impact. Certainly not enough impact for some, too much impact for others. And of course, then there's the question of constitutionality. One of the provisions, of course, has to do with firearms ownership, which has been very clearly and for many decades, almost a century actually, has been clearly under federal jurisdiction.
Yeah, that one is a really interesting part of the proposed amendments. The amendment is supposed to protect the right to acquire, keep, and use firearms in accordance with the law. This is now being proposed in the Alberta Bill of Rights. And, I do, Lorian, see the argument that this could have federalism implications to the extent that firearms are subject to criminal law, which is a federal head of power. Do you think there's going to be a jurisdictional fight on this? We've only got a minute, but we can continue into the next segment on that as well.
I think the important thing is that wording in accordance with the law. They're saying that this isn't trying to guarantee or create new rights, but rather is guaranteeing rights in accordance with existing laws. And so that to me implies that there isn't an intent to constitutionally overstep. And we did also hear from the premier that she recognizes the federal criminal law jurisdiction, but is dealing more with the property and civil rights piece.
I mean, it's certainly, there's been a lot of case law on shared jurisdiction of late, a lot of it coming out of Alberta. Usually, though, it seems to be going the other way, that the federal government is more often uh, sort of sued by the Alberta government for intruding into their jurisdiction. So it will be interesting to see how this plays out. We've got to go to commercial break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing amendments to the Alberta Bill of Rights. Now, Lorian, this is a proposed statutory Bill of Rights, so it's not a constitutional document. There are other provinces that have things like this. Quebec is the one I think of. I'm actually not sure if other provinces do, but maybe you could enlighten me. Um, Now, Quebec has called theirs, it's the Quebec Charter. It has a lot of provisions that are similar to the Canadian Charter. So how would you compare all of these documents? Is the Alberta change more similar to the Federal Bill of Rights, more similar to the Canadian Charter? How does it compare to the Quebec Charter? Should we think about all of this?
Yeah. So in some ways, calling it a constitutional Bill of Rights versus a statutory Bill of Rights, they're all trying to really accomplish the same thing, which is ensuring that it sets out general principles for the laws and policies of that jurisdiction, and making sure that they adhere to what's contained in this legislation. Now, if you dig in more deeply, of course, the federal charter, for example, is quite difficult to amend, and so it has maybe more permanence than a bill like this that can be amended through the regular processes in the legislative assembly. But they're all kind of getting at the same thing of setting these broad rights and freedoms that people are entitled to in the relevant jurisdiction.
Now, Lori, one of the things that I'm interested in is the impact that this could have. So we've talked a little bit about that. One of the things I want to ask as a follow up to that, though, is, these are amendments to the Alberta Bill of Rights. How often was the original Bill of Rights that Peter Lougheed brought in, whatever it was, 50 years ago, how often was that being relied upon?
Not very often. I actually did a little bit of a search to see if there was case law based on this, and most of the references to any Bill of Rights is to the Canadian Bill of Rights. There were a couple of cases that dealt with property and expropriation, um, and of course, probably in most cases, what people relied on it when it came to rights in Alberta was just Alberta human rights legislation, things involving the Human Rights Commission, and so forth. So the very existence of this Alberta Bill of Rights was really low on the radar, wasn't being used very often, wasn't a primary focus for most people. And I'm just curious if that focus on the Bill of Rights and the language of the Bill of Rights might be coming from a lot of folks, again, on the right side of the spectrum, who seem to see things in the Canadian Bill of Rights and potentially in the Alberta Bill of Rights that can give them things that they don't have under current law. I don't see anything written here that is going to accomplish that. But again, much may depend on what other laws or other legislation the Alberta government wants to bring into effect, and how the courts deal with it.
Now, Lori briefly mentioned the expropriation aspect of this bill. We don't have to get too deep into it. It proposes certain protections against property being expropriated. But really, at a high level, how would this be different from legislation that already requires compensation when government expropriates property, or the common law requirement that exists even in the absence of legislation that requires compensation for expropriation?
Absolutely. So it isn't actually clear how this is going to advance the law and what new legal protections it gives. And to my mind, it doesn't seem like it's going to do a lot in that regard. And so to me, this may be more about the symbolism than about actually expanding legal rights. The other thing we haven't heard from the government is what problem this is intended to address. So, for example, some of the other parts of the Bill of Rights, we can see what clearly the government was doing. So, for example, responding to dissatisfaction over COVID-19, or responding in the firearms piece to this federal provincial infighting. But it isn't actually clear what the underlying problem or motivation was with the expropriation piece. So I hope that we hear more from the government on that issue as well.
Lori, anything you want to add there in about 45 seconds?
Yeah, so one of the things that inspired this or put pressure on the government here were demands being made by this document produced by the Black Hat Gang that included the possibility of publicly carrying firearms using lethal force to prevent or respond to a crime in progress. And of course, that has to do with property rights. Reminds me of stand your ground kinds of thinking coming out of the United States. And again, much of what this government is doing is being inspired by things that are going on south of the border and isn't, I think, very well tailored to the realities that we face here in Alberta.
We've got to go to commercial break, but when we come back, I want to talk about those limitation clauses that exist in these proposed amendments. We'll be right back. Welcome back to Canadian Justice, where we're discussing the Alberta Bill of Rights and some proposed changes. Now, one of the things, I mean, Danielle Smith has drawn some criticism from the left, the right, from a lot of people over these proposed changes to the Bill of Rights. And one of those pieces of criticisms is that the Alberta Bill of Rights contains a number of limitations clauses. There's something similar to a Section 1, which allows for justified limits to rights. It has something like the Charter's Section 33 notwithstanding clause, which allows the government to essentially, I mean, this isn't the best language, but place temporary overrides on rights. Lorian, what's your take on these limitations?
Well, I think that it's important to have those limitations clauses in place. We can't have completely unfettered rights because, of course, you can end up in situations where two rights are in conflict, and we need some principle on which to address that. And so, I think Section 1 equivalent would do a lot of work here. That rights are subject to reasonable limits that are demonstrably justified in a free and democratic Alberta. I think that'll do a fair bit of work. And then there are also limitations clauses in at least one of the rights. So the right to be free from medical coercion has a carve out for situations where someone lacks capacity and poses a substantial danger. So there are even carve outs or limits on some of the rights themselves.
So would that carve out on the medical protections, would that apply to things like involuntary medical treatment when a person is suffering from a disease or something like an addiction? These are really hot button issues right now. I know there's legislation in other parts of the country that deal with involuntary medical treatment for people with serious mental diseases and addictions. Is that carve out designed to apply to those situations?
Yeah, it's really designed to apply to two pieces of legislation. One is the existing Mental Health Act, which was the subject of a charter challenge not that many years ago. And then the other is the government has said they're going to introduce so-called compassionate care legislation that would allow for the compelled treatment of individuals suffering from addictions. And so we might actually see some interesting litigation about whether the government's new compassionate care legislation is consistent with its new Bill of Rights.
Lori, anything you want to add to that or to the limitations clauses in the Bill of Rights?
I think it's important to understand the broader context on limitations clauses. Those were introduced, particularly the notwithstanding clause kind of idea, basically affirms legislative supremacy. In other words, the legislature that represents the democratic will of the people can protect legislation that does reflect the will of the people from the effect of a court challenge that is too restrictive upon that. And that's actually that limitation of the courts idea is something that tends to be quite popular in conservative circles, but it is not being received well by the conservatives that I've mentioned before. David Parker, Nadine Wellwood, Leighton Gray, these representatives of these three groups are all saying that it essentially nullifies what this Bill of Rights can do, and they're also, of course, critical that the Bill of Rights doesn't reflect what they were demanding in the first place.
That's such an interesting point because I see that happening as well. I see a lot of there's certain groups that might cheer on the use of the notwithstanding clause federally, but now provincially are critical of its inclusion in the Bill of Rights. I hadn't thought of that. That's really interesting. Uh, Lori, we've only got about 45 seconds left. Is this initiative helping or hurting Premier Smith?
It's probably hurting her, but based on the reaction that I've seen so far. So we know that there are regularly scheduled leadership reviews for leaders in the United Conservative Party, but there are those that can be forced either by the board of directors or by
Mhm.
a certain number of constituency associations. So the pressure on Daniel
Mhm.
Smith's leadership, the criticism from those to the further right and those that are more moderate, those will continue. And I think it's a
Mhm.
ripe opportunity for either others who want to take her
Right,
place within the party
right.
or opposition leaders to take advantage of this.
Fascinating. Lori and Lori, thank you both so much for joining today. We've heard today about the updates to the Alberta Bill of Rights. Are these amendments important updates to protect the rights of Albertans? Will the changes provide a bulwark against government overreach, or are they a redundant political exercise? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.